Suppose the owner of a parcel of land decides to sever the parcel into two plots, one of which has no access to a public road. If the owner then sells the landlocked plot to another person, an implied easement of necessity arises, allowing the purchaser to cross the plot retained by the owner to get to the road. Now suppose years pass, and both plots are sold many times over to new purchasers. Do subsequent purchasers still have that easement? The court discusses that question in Roy versus Euro Holland Vastoed. Henry Buckman owned a large parcel of land. In 1913, Buckman subdivided the property into multiple tracts. Buckman sold one of these tracts to Frank and John Coventry. The only access to the Coventry's tract was across the portion of land retained by Buckman, which abutted a public road. The Coventry's tract was sold many times thereafter, eventually being owned by Maurice and Lillian Roy, whom we'll call Roy. The land that Buckman retained was eventually sold to Euro Holland Vast Hode. Because Roy couldn't get to his property except across Euro Holland's property, Roy filed suit in state court seeking an implied easement of necessity over Euro Holland's land. After a non-jury trial, the trial court entered judgment against Roy. The court concluded that Roy hadn't established the necessary unity of title in a common source, because Roy's grantor had never owned Euro Holland's land. Roy appealed to the Florida District Court of Appeal.